Well, welcome everyone. So great to see all of you virtually for our session today. I'm Tom Gallagher. I'm professor and associate chair of the Department of Medicine at the University of Washington and executive director of the Collaborative for Accountability and Improvement. And we are just so lucky today to have Dr. William Sage leading a webinar for the Collaborative entitled Observations on Accountability and Improvement from the Vanderbilt Nurse Case. Dr. Sage is an authority on health law and policy and is a tenured professor in Texas A&M's both medical and law schools, a professor by courtesy in the Bush School of Government and Public Service at Texas A&M, and a vice president in the university's Health Science Center. From 2006 to 2022, he held professorships in law and medicine at the University of Texas at Austin, where he also served as vice provost for health affairs. He was previously a tenured professor at Columbia Law School and has been a visiting professor at Yale, Harvard, and NYU. Dr. Sage is a member, a leading member, I would say, of the National Academy of Medicine, where he serves on the board of healthcare services and recently served on the committee on the future of nursing 2020 to 2030. Bill has written over 200 articles and has authored or co-authored or edited 4 books, including the Oxford Handbook of U.S. Health Law in 2016. He has an undergraduate degree from Harvard College, medical and law degrees from Stanford University, and an honorary doctorate from Université Paris Descartes. And Bill speaks French, which I learned on a trip with Bill to Paris to present a program together at that university, so he can provide us with the appropriate presentation. Just on a personal note, I just wanted to share how indebted the Collaborative is to Bill for all of his helps. He co-led the Policy and Advocacy Committee for the Collaborative for many years, is really a leading light in the field of health law and communication and resolution programs, has been a nice friend and mentor for me personally, and I am told he makes a mean French toast. So if you ever want to test his culinary skills, you'll have to invite Bill to be visiting professor and make sure he has a kitchen to work with. So with that, Bill, let me turn things over to you, and we'd love to hear your thoughts on this tricky case.
Thank you, Tom, and hello, everyone. That was an absolutely lovely introduction. My French toast is far better than my French language, just to be clear. And as for any other inaccuracies in what you said, we'll just let them slide by for now. I'm very happy to be with you. This is a very interesting case, and it's one that has made me think deeply about a number of issues. And what I would like to do today, Nicole, let me just check with you. What are you seeing my slides? Because my screen shifted a little, so we're still.
See your slides perfectly.
Very good, thank you. This made me think about a number of issues that didn't seem to be part of the press coverage and professional response to the situation, and I just wanted to share those thoughts with you today. I'm not going to make a disclaimer about, personal versus institutional views, though obviously I do not speak in any way for the Texas A&M Health Science Center. I do speak as a faculty member in multiple schools there. But the relevant disclaimers are as follows. My impressions here are based on what's been public and based on a few fairly casual conversations I've had with some relevant experts in these areas. I have not read transcripts, I have not listened to hearings, I have not been part of any of the formal legal proceedings associated with this case. And I think an important thing to say, I have absolutely no confidential or inside information about this case. If I have drawn some faulty conclusions, they're based on reasonable assumptions and experience. And if anybody wants to challenge or correct me, that is absolutely welcome. But I'm not speaking as an insider in any way on this case. What I'm hoping to do is have much of this be a discussion, because to be frank about this, many of the things that I see in this situation are not the things that people who are immersed in hospital risk management, in medical liability, in sort of patient safety at the individual professional level or at the system level, or frankly, in a fair amount of the communication and resolution movement, seem to have spent much time with. Perhaps people have noticed them, perhaps people have factored them in some way, but they tend to be things that I think are by and large overlooked, and they're very much, to my mind, presented in this situation. So the bold here is the notion of private accountability around medical errors versus public accountability. And this is something that was mentioned by Jerry Hickson back at the end of the summer in one of these webinars, but it's something that I think we need to talk a whole lot more about, and we'll do some of that today. And that's particularly relevant when you have an institution like Vanderbilt University and Vanderbilt's Medical Center that plays a prominent role in its community and has a local, national, and international reputation. The public accountability here is something that we really do have to talk about. Another thing that I want to talk about is the notion of criminal liability. And criminal liability is attached to the notion of public accountability. Criminal charges are not vindicating private interests, they're vindicating public interests. We know the flaws in all of our systems of legal accountability, from self-regulatory mechanisms to tort litigation to the criminal justice system, which has some truly unforgivable attributes today, though those don't seem to be attributes that are much in evidence in this particular case. And it's not that any of these systems is without significant flaws, it's that these systems do serve fairly well understood and fairly well acknowledged purposes. What I'm going to do from this slide, and I don't have a lot of slides, is I want to talk about a little about the criminal liability part, a little about the regulatory setting, just from this slide, without going into sort of additional detail, and then we can talk about all of these issues in conversation, which I gather Nicole and perhaps Tom will moderate after I'm done presenting. Then I do have some specific additional slides on the last two major points on reporting and disclosure, and on the practices that persist in the settlement of potential or actual tort liability in cases of patient injury. So let me just make a few comments on the criminal liability side. So our criminal justice system typically operates under state law. Most criminal authorities are state authorities. That empowers generally county level local prosecutors to bring cases when it is within their jurisdictions and when it seems to rise to a level of serving a public interest. And I'm not naive about the motivations of prosecutors, and we can talk more about that. But basically, most cases involving what we think about as a sort of basic crime or raw crime, certainly including physical injuries and homicides, goes through state prosecutors. There are statewide prosecutors, state attorneys general, who certainly have criminal enforcement jurisdiction and authority, but typically at the periphery. And federal crimes tend to have both an interstate character, but also are typically the types of offenses that either involve national security or some general national interest, or which have to do with the primary function that the federal government plays in our system of government, which is providing money, and therefore all sorts of things involving the mails, the wires, and financial transactions of various sorts, and particularly in healthcare, financial transactions involving government funding provoke federal criminal enforcement. But federal and criminal enforcement is rather a different thing than state criminal enforcement. Yes, individual U.S. attorneys' offices have a good deal of discretion, but things are actually much more centralized in terms of review, authorization, and policy from Main Justice in Washington, D.C. and the U.S. Attorney General than would affect any local prosecutors prosecuting state crimes. So one of the interesting issues for me in criminal liability in this particular case is that what we saw was a state level criminal prosecution and criminal conviction for negligent homicide and abuse of a vulnerable person, in this sense, an elder abuse of someone who was a patient and vulnerable in a hospital setting of an individual nurse, Redonda Vaught. That is the sort of crime that one would expect to be prosecuted, as indeed it was, through state authorities at the local level. And because it has aspects of sort of elder abuse and the like, it might also involve the role of a state attorney general, but in this case, it seems to be largely a function of a local prosecutor. Something we haven't really talked about here is actual and potential corporate criminal liability. And I'll just, because I don't know the exact relationships, let me just say for Vanderbilt, I don't know exactly what corporate entity would be potentially on the hook. But this is something that I think has been, underappreciated in this particular case. Although we could say blithely, well, you can't put a company in jail, we prosecute and convict corporations all the time for various offenses, and something that I think needs to be thought of in this world of public accountability in this and similar instances is what was Vanderbilt's potential criminal exposure. As a practical matter, the local prosecutors were very good at categorizing and enforcing against individual sort of bread and butter criminality. Don't tend to be the same organizations that are equipped to bring more complex cases against corporate entities, but something that I've not seen covered in the basic coverage of this case, other than one passing reference to the Tennessee Bureau of Investigation only doing a criminal investigation of the individual nurse and not of Vanderbilt, is Vanderbilt's potential criminal culpability here. And I think that the criminal culpability would be considered sort of at two levels. One would be the actual death of this patient. The other would be the acts and omissions of Vanderbilt in terms of its conduct following the events, and particularly its failure to adhere to reporting authorities. So one of the questions I put on this slide in terms of potential criminal liability, both individual and institutional, is how unsafe was the Vanderbilt care environment? And it's something I don't really know the answer to. We all know the basic facts of the situation. We know that it's a 75-year-old woman admitted for evaluation of a subdural hematoma. We know she was going for imaging. We know that a sedative was ordered, and instead of paralytic agent vecuronium was administered. We know that she arrested, was resuscitated, but ultimately died after profound and prolonged anoxia. We know that basic situation. We've heard things about the practice that nurses had to follow in order to override what were intended to be patient safety safeguards in dispensing and accessing and identifying medication. We've been told in many instances that, well, this nurse doesn't seem unusually culpable because all the other nurses were doing similar things on a routine basis, almost as instructed, it seems, by Vanderbilt. And that actually raises, to my mind, some very interesting questions. I'm not saying that a corporate homicide prosecution was warranted, but it seems to me that Vanderbilt had, at least at that moment in time, created an environment in which many of its health professionals were forced to take reckless actions on a routine basis. And I find that quite worrisome. But more to the point of corporate criminal liability is the distinction between the crime and the cover-up of the crime. And I think this is the part that I'm constantly surprised that the people who I think are the most passionate advocates for patient interests, for honesty to patients, for system improvement, don't seem to notice that from the perspective of a prosecutor who, with all of the sort of motivations prosecutors have, thought of him or herself as representing the public interest, this situation looked like a cover-up. Whatever the original injuries were, whatever the causes of the original injuries were, the events happened in 2017, towards the end of that year. The institutional response was essentially immediate. I don't know the details of the timing of the outreach and the settlement with the family, but the regulatory response is delayed basically 2 years, and the criminal prosecution happens substantially later than that, because the information that might have vindicated a public interest, had it existed in this situation, was not available to the public through the usual vehicles of regulatory or publicity accountability, informational accountability. And so, if I'm a federal authority here and I'm thinking about the culpability of an institution, I'm less thinking about a connection between my criminal prosecutorial authorities and the death of this patient, but I am very much thinking about the obligations that a major medical center in receipt of very large amounts of federal funding has to comply with its regulatory reporting and disclosure obligations. And the omissions here at least bear investigation. I have no idea, as I said, I don't have inside information. I don't know what the underlying facts are. We've heard some discussion of this from Jerry Hickson last time, but from the perspective of criminal accountability, I'm not surprised that the nurse was held criminally liable. It was, after all, a conviction on the lowest level of the available offenses, and the sentence was a probationary sentence, which fits neatly within what one would expect in this sort of a situation. The sky is falling predictions about 9-year prison sentences that followed the conviction pre-sentencing were, for anyone who has experience in criminal prosecutions, very, very unlikely. And the probationary sentence was not a moment of enlightened mercy. It was a fairly routine outcome in a case handled through the usual processes that has this general sort of character and these general people involved. So that's what I wanted to say about the criminal liability part. I'm not going to show any other slides. We can certainly come back to any part of that in conversation. Just briefly about licensing boards and state departments of health, whoever the facility regulators happen to be in a state. So Nurse Vaught was investigated by the Tennessee Board of Nursing, which initially decided not to pursue disciplinary action against her, and then ultimately, as the criminal prosecution unfolded, reconsidered, investigated, and even prior to the criminal conviction, I believe, revoked her license to practice nursing in Tennessee. It is not, I've not seen any particular information about how hospital regulators responded to the Vanderbilt situation either early or late. And because this involved a medication error, the federal FDA had some interest here at all, but the interest here as well. But the FDA is not typically vis-a-vis healthcare providers, either physicians or hospitals, a frequent enforcer of its rules and laws. So it's really more the licensing boards, state, and the state regulatory authorities. Now, certainly if one looked at Vanderbilt's lack of compliance with federal authorities connected, say, to the Medicare or Medicaid programs, then the Federal Department of Health and Human Services, the Office of Inspector General, what we tend to think about as the fraud and abuse apparatus, might have a say here. It's interesting to me to see that there's an expectation that the licensing board will get involved if that is warranted, and the fact that it was relatively hands-off at the beginning didn't seem to surprise anyone. Licensing boards, as we all know, tend to be under-resourced and typically under-informed about things that might actually be within their jurisdiction, although many states do require licensed physicians and other licensed health professionals to report events that endanger patients. Those reporting obligations are generally framed in terms of immediate and repeated dangers to patients, and are almost never enforced against a licensed professional who fails to report somebody else. So the licensing board and the hospital regulators have a sort of, they hang in the periphery here. People are nervous about them, but they don't really get involved that often and that directly. So let me, but I'll flag all of that, and we can also talk about those if we've collected any chat comments or questions. Let me now turn to the two areas that I really just want to talk a little bit more about. One is the failure of Vanderbilt to fulfill what appeared to be its legal obligations to explain to the FDA what happened with this medication error that resulted in a patient's death. More importantly, to report to its state regulators at the facility level the circumstances of this patient death. And we also could, I've read in passing in the public record that the death was reported as natural causes to the local coroner. I don't have a comment on that. The involvement of local coroners in death records usually is not closely connected to the patient safety enterprise. I don't know if it should be or not. But there's some interesting things to think about in the world of mandatory disclosure. And these are things that I've worked on for the 30-year length of my academic career. These are very familiar and important issues to me because the sharing of information seems a less intrusive regulatory intervention than a specific requirement to do something or a specific prohibition on doing something else. And so we have, particularly in healthcare, where so much of what we actually provide to patients is at its heart information, we have a lot of information-based regulatory obligations. I'm going to come back with one slide about sort of the range of the goals in a moment, but I want to address head-on this issue raised by Dr. Hickson last time, that it was hard to report one's mistake knowing that one's, I'll call them competitors, rivals, colleagues in other facilities seem to routinely underreport. Can you justify failing to report because nobody else is reporting? And I understand that sentiment. If reporting obligations aren't enforced, then it might well be that you feel that you are going to be unfairly singled out when you do the honest thing and step forward to say what happened. What I would respond beyond the, I hope, obvious ethics of following the rules here is that if you believe that under enforcement is a problem, you should advocate for more enforcement. You shouldn't advocate for non-reporting and non-compliance. You should advocate for harsher penalties for failures to report. Let me give you an example I just learned yesterday. I was presenting at a Texas State Health Law Conference, and one of the other presentations I learned about was federal laws regarding ransomware, malware, and breaches of cybersecurity, including many involving healthcare. The federal government does not take the position that you shouldn't pay ransom to someone who has hijacked your systems and has threatened to corrupt them and destroy information. The government does not take that position because the government does not want to put people in a position of being blackmailed twice, once by the people who want to be paid off, and another time by the potential liability to the government for having done something unlawful. But here's what the government does. The government requires that ransomware payments be promptly and accurately reported. And the penalties for non-reporting are very, very substantial. This is helpful to systems whose data gets compromised, and here's why. If everybody is routinely reporting and you report, you do not stand out as someone who's uniquely lax about your cybersecurity. You don't stand out as someone who's uniquely culpable in making your information vulnerable to hackers. It becomes a routine activity, and you can report without fear because everyone else is reporting. And one thing we have not seen in healthcare is serious enforcement of these types of reporting obligations. The last point in the disclosure world is that here's where we get this very interesting interaction, particularly evident in the Vanderbilt case, between how you treat patients and families and how that will be interpreted when considering an interest of a broader public. And so much of the world of sort of new forms of malpractice approaches, communication resolution, and a host of these things all exist in a very dark shadow of 25 or so years of malpractice insurance crises and a lore, as opposed to a law, of medical liability that still holds tight on a surprising number of at least older generation physicians and health professionals. And so, embedded in what I'm talking about is a strong request to reconsider some of these habits and biases and norms in the interest of doing better for both your patients and for the public. Here's just to be clear, there's multiple reasons why one requires public disclosure of information. Some of these are market competitive reasons, giving people better choices, particularly about quality, but also presumably about price. Some of these are safeguarding relationships of loyalty and fiduciary obligation between a corporate manager and a shareholder, between a doctor and a patient, between a lawyer and a client. Some disclosure obligations are in order to generate more intrinsic interest in improvement. If I am going to be measured, I am going to manage what is being measured. Sometimes that, leads us astray, but the fundamental observation is an accurate one. And if an outside party can't benchmark what my performance should be, at least if I and everyone else is saying what our performance is, we begin to get an idea of what range of improvement exists. But there's also a public interest, particularly in exposing biases, favoritism, corruption, or inaction in government to public view by getting more information out there. And in instances involving individuals and injuries, even if nothing can be done with the information, generally we acknowledge a dignitary right to tell people something that affects them, even if they can't do anything to protect themselves or to remediate that instance, or even perhaps protect themselves in the future. And so when we talk about a right to know, we're often just talking about treating other human beings with dignity when something has happened that affects them. And I don't say this, in that we're going to, do a percentage weighting in terms of Vanderbilt's reporting obligations, but I do this to say that there's a lot of theory behind why you have disclosure and reporting obligations, and before one ignores them or caricatures them, one should at least consider this range of possibilities. What we also see when we have public exposure is that things like reputation, there's a famous Lincoln quote that character is the tree and reputation is its shadow. Reputation is a curated image related to, but not identical to, reality. And the informational environment is one of the ways in which reputation and reality potentially converge. Also, there are norms that sometimes providing more information reinforces a beneficial norm, say a norm of inclusion of a patient in a discussion of therapeutic possibilities. There are also times when exposure is intended to supersede a norm, showing where racial discrimination exists in housing or lending or something like that. Those regulators who need to set standards, sometimes they learn from the information disclosed what that standard should be, who should set it, how it should change. Thanks to the way we transfer information these days, what used to be a fairly significant distinction between an obligation to report something to one's regulatory oversight process and an obligation to disclose something to private individuals or the broader public now converge. And that's why we have so many instances where things that are reported are then publicly posted. And I'm not saying I'm in favor of all those situations, but there used to be a distinction between reporting and disclosure that's no longer tenable because of technology. And finally, I say in passing, but this is extremely important for all sorts of things in the real world, particularly the relationship between hospitals and their employed or affiliated professional staff. There is a world now out there of Supreme Court-led jurisprudence that attaches far greater First Amendment privileges to both individual and corporate speakers, and makes it much harder for government to regulate information by either requiring or prohibiting particular information from being shared. So that's a little mini lecture on the world of disclosure, but I mention it because there's so much in this case that seems to be not discussed regarding what the obligations were of Vanderbilt to report and why they weren't followed. And then I want to sort of end in terms of the formal presentation with sort of one of two related papers from the same data. These were ARC grants that Eric Thomas and I and others, Tom and part of them, were involved with several years ago that were supposed to be about communication and resolution programs and tracking conversations to see the impact on patient safety. The piece I had was looking at not just the closed claims, but even open claims from the University of Texas system, which in conjunction with the Texas Attorney General's office is responsible for processing, handling, resolving claims involving thousands of University of Texas physicians across a number of cities and major institutions, and affecting tens to hundreds of thousands of patients every year. We had, thanks to Ken Shine, at the time the executive vice chancellor for Health of the University of Texas system, really unprecedented access to system data. We also had what was even, I think, better, which was the ability to look at data and then go immediately talk to the people who had been in charge of these cases and had presided over their settlement. And what came out of these data very quickly, painlessly given unprecedented access, was that overwhelmingly these agreements, even in an environment that espoused principles of honesty and improvement, almost uniformly and without much rhyme or reason, prevented patients and their families from saying pretty much anything about what had happened to them or how their injuries were resolved. So we looked at 110 settlement agreements within our study years, and here you see the things that were prohibited. All prohibited disclosing the settlement amount, all prohibited disclosing the terms of settlement, most prohibited disclosure to the media, most prohibited disclosure that a settlement had been reached. A little more than half referred to the lawyers as being part of this. Almost half prohibited disclosure of the facts of the situation. And an interesting thing is when Texas in 2003 adopted strict tort reform, previously not permitted within the state constitution and not legislatively favored until the Republicans took over the Texas legislature, the prohibitions on disclosing the facts of the claim as a condition of settlement increased, and far more than half prohibited that. A quarter prohibited reporting to regulatory agencies, et cetera, et cetera. Only a couple prohibited disparagement of the settling defendants by the plaintiffs and participation in other lawsuits against the same defendants. This was the most common clause that was used in these settlement agreements, though there was a wide variation and nobody had strategically and uniformly investigated these. Obviously, you could see from the range of language that these things had come into being on individual campuses based on individual experiences, and nobody was sort of theorizing and then implementing any particular form of non-disclosure confidentiality provision in these. But you can see claimants agree to keep confidential and secret. Start, the facts and events made the basis of this claim. I really want to draw your attention to that. Then a bunch of other things. And then in the second paragraph, this agreement specifically means that claimants agree never to disclose to any members of the media, any organizations or companies, any governmental entities, the Texas Medical Board, even in an anonymous complaint, and any other organization regulating healthcare in any manner. So what's obviously bizarre here? What's obviously bizarre here is that the University of Texas system is an arm of Texas state government. And an arm of Texas state government is, in its tort settlement agreements, prohibiting claimants who are settling from talking to other arms of Texas state government. Now, California prohibits these types of provisions by legislation. If challenged in court, most of these provisions involving non-reporting would be held invalid as against public policy. Of course, settling plaintiffs don't know this. They just know this is the agreement they signed. We pointed out the I don't know what to say, impropriety of this restriction on regulatory reporting to the people who ran the office for the University of Texas. They looked at them and said, "You're absolutely right." And they took them out of the agreements. And we actually did a follow-up study where we saw that they were out of the agreements. Now, are they still out of the agreements 15 years later now instead of the 5 years later then? I'm not sure. And if there's been backsliding, that's also something that people should pay attention to. But you might say, okay, this is Texas, it's 2015, and it's public hospitals, and maybe it really isn't what we do today. It is what we do today. So without any identification, this is a clause just shared with me by a major, highly reputable, highly successful plaintiff's firm. It's interesting to see the differences here. The undersigned shall not comment on any aspect of this case or settlement to any member of the news media or publicize or cause to be publicized the facts, the existence of the settlement, the terms and conditions of the settlement. If the undersigned file any court documents, they shall request that the documents be sealed and try to keep them inaccessible to others. At least this focuses on the notion of motivated adverse publicity, as opposed to simply any statement about the facts of the case, but it still troubles me significantly. Now let's take this situation and put it in the context of Redonda Vote and what happened at Vanderbilt. I am quite confident, without inside information, that the local district attorney got wind of this situation from someone like a family member, possibly an extended family member who was not a signatory to the settlement, because that individual and probably the rest of the victim's family were feeling really, really queasy about what they had done and were very troubled that there had been no form of public accountability really in any venue for Vanderbilt or for the nurse or for anybody else involved on the provider side in this case for some number of years. I think all of us have at least had anecdotal experiences with families who think that their silence has been bought and they have betrayed the memory of their loved one who has died from a medical error when they signed off on a confidentiality provision of any breadth in connection with receiving a settlement. This stuff does not sit well with family members over years. We also, I think, are all acquainted with the family members who refused to sign those provisions, refused to accept the settlements, and then became patient safety advocates. And my experience of that has been those have typically been better educated people who have more money in the bank and have the freedom to ignore that settlement and the confidentiality language that comes with it. But in the Redonda Vote case, I think we can say that we have a link between the ways in which these types of confidential settlements impact families and make them deeply uncomfortable, or at least make some members of the family deeply uncomfortable. And then the response of the district attorney who said, oh, okay, you're now telling me all of this and nobody's held Vanderbilt responsible and Vanderbilt hasn't complied with its various reporting obligations and nobody's actually disciplined this nurse in any meaningful way, though she did lose her job at Vanderbilt almost immediately, which is itself an indictment of the lack of further public accountability. And therefore, a local prosecutor will investigate and if warranted, take action. And I have a very blunt view of these disclosure or should say non-disclosure provisions in malpractice settlements. I think they should focus on non-disclosure of the amount received, which I think is completely reasonable. And I think they should contain non-disparagement provisions, which might be adapted from the language you see here, so that a settling family cannot then, very directly badmouth a system or a provider, health professional, physician, or nurse in the media having accepted the settlement. But prohibitions on talking about the facts of the case, I think, are deeply misguided from both a serving your patient and your patient's family perspective and from a perspective of public accountability. So that's all I have for slides, and I'm happy to have a conversation.
Thank you so much. We have had some questions start to come in, comments and questions. So to everyone else, please feel free to submit them at any time and we'll go through them and get through as many as we can. I will start with the question the first one that came in. It says, in terms of corporate criminal liability and accountability for patients and the public, what would be the best way to hold hospitals accountable? It has always been difficult for patients and families to find any individual or corporate accountability in a meaningful, transparent way.
It's a very good question. I will disclaim that although I have a lot of experience indirectly with corporate criminal prosecutions, I've never been a corporate criminal prosecutor or a white collar defense lawyer. In this instance, I think that a beneficial focus of corporate accountability should really be around the reporting obligations. I think there should also be a willingness in circumstances, and I again, without any inside information, I am deeply troubled by what sounds like a transition in an AHR system where the workarounds were all requiring an environment for nursing staff where they were acting recklessly, even though they didn't necessarily know the consequences of their conduct, as well as, say, fully trained physicians might have in those situations. I mean, I can't imagine opening a vial of vecuronium, clearly labeled, reconstituting it and administering it, thinking it was some other drug. I can't imagine doing that, but obviously at least one nurse did, and I imagine other nurses and others might well have done. To me, that is the responsibility of the institution. And so, you know, I think in these instances, in the rare circumstances where criminal prosecutors get involved, I think it's perfectly legitimate to consider the institutional accountability as well as the individual accountability. Harder cases to bring probably are not going to be brought very often, typically are not within the wheelhouse of a local prosecutor, but I think it's worth being open to that. But ultimately, I think the big lesson of this for criminal accountability is informational. This looked like a cover-up. It may have not been the intention of the participants, but what I've heard so far and read so far, again, without any inside information, seems like a lot of rationalization and in general, a failure to appreciate that from the perspective of a lot of people who got wind of this a couple of years later. Nobody stepped forward to say what had happened in a way that was meaningful to the public. And if I were going to constitute criminal authorities at the institutional level, they'd be designed to prevent cover-ups more than they'd be designed to investigate and punish the initial events.
All right. Our next question says, is it your experience that institutions might neglect to report incidents to the National Physician Database? I think that's NPDB.
Tell you what, why don't we read 2 or 3 more and then I'll synthesize them.
Okay. Let's see. Another question or comment says, please comment on nurses now not coming forward with mistakes given they are afraid of being prosecuted, and it makes it impossible for hospitals to address if they don't know about it. And then we also have, should hospitals be accountable for acts of contracted employees?
Okay, one more.
And then, do you see prosecution of medical professionals being a regular occurrence as a result of this case?
Okay, let me start with the last one because easy. No, I don't see prosecution of medical professionals becoming more common as the result of this case. I think this case is really motivated by the cover-up. I think the tort settlement practices added to the perception and, frankly, in my view, the reality of a cover-up. And I think that was the criminal response was more directed at that than was directed at the circumstances. I don't see this as somehow beginning criminal enforcement. I do think it's worth everybody acknowledging that that tort liability has been, for better or for worse, the principal form of quality-related after-the-fact accountability in the United States. In other countries that don't have that tradition, they can have much more frequent intervention from the criminal justice system. There are countries where criminal investigation of medical errors is fairly routine. It's a different criminal justice system, but it's also a different tort system. And I just think everyone should be realistic that if, people have been advocating for restrictions on tort liability, that doesn't mean restrictions on overall accountability. And if it's harder to bring private lawsuits, I think, you have to acknowledge that regulators, licensing boards, and potentially prosecutors are going to get involved more often than they have in the past. Now, let me go back to the first three, which I think really raise an unanswerable but extraordinarily important question, which is we have a healthcare system that is built on sort of individual prerogatives for physicians, typically with billing codes that generate revenues based on everything they do, and then institutions that are thought of as doing best when they're hands off with respect to physicians. The system that we now have is not that system. The system we now have, there is a much closer alignment, often an employment relationship between hospitals and other provider organizations and individual professionals. And there are going to be a lot of frictions involving the established channels of accountability, given that the relationship between institutions and their constituent physicians are rapidly changing. And I think that's an area where people should try to be really thoughtful and try to come up with things that are better aligned with the present system than what we've had in the past. Nursing, I do a lot of work on nursing. I was very proud of serving on the last Future of Nursing committee. I have been an advocate for expanded practice privileges for nurses, not just advanced practice nurses, but nurses across the board for decades. Here, nurses have the opposite problem. Nurses have been regarded by hospitals as always on the cost side of the ledger. Physicians presumptively generate payments for the things they do. Nurses presumptively constitute high levels of undifferentiated labor cost for hospitals. They are often without voice. They are often without power. They are not typically treated that well within their organizations. And although this is a pre-pandemic case, I think it gives a very good indication of what in sort of the world of post-pandemic healthcare workforce stresses we can anticipate going forward. So I think this is a wake-up call. Even though I'm not offended by the prosecution of this nurse, I'm certainly not offended by the probationary outcome of the prosecution and conviction. I think this should be a wake-up call to hospitals to think about better ways to empower their nursing workforce. And frankly, over time, when nurses do things that are beneficial, nurses and by extension hospitals should be paid for those things. Nurses as just sitting on the cost side of some accounting ledger, I think, is incredibly destructive to high quality healthcare and accessible healthcare.
All right, I'll read a few more questions for you. Dr. Sage, we have CMS investigational results on individual providers are also prohibited to be shared with state medical boards under the federal confidentiality law. Is it wrong and against every principle of transparency?
Why don't you do a couple more?
Okay. And then the next question says, can you speak about the danger of prosecuting providers and nurses for medical errors? And the additional question that came in, I'm not sure you can speak to, but it says, what role did Vanderbilt play in their system design?
Okay, so I don't have any inside information about Vanderbilt. I do have a very high regard for people at Vanderbilt, and in many ways, they've been leaders in patient safety and healthcare quality, which is why I think this would be a very good opportunity for Vanderbilt to do a public self-examination and come up with a few things that they could have done better here, because I'm sure those things exist. Again, you know, if the fear is corporate liability for health professionals, I don't see it. As I said, I think corporate accountability for reporting obligations could be extremely important. Again, using that cybersecurity example, if there are significant penalties for non-reporting of things that people are aware of having done or failed to do, you know, if everybody reports, no reporting institution gets singled out as unusually bad. This environment where we had non-reporting here in part justified by under-enforcement of reporting obligations, the solution is not getting rid of the reporting obligations. The solution is to enforce them. Design them well, but then enforce them. And remind me what the first question was that you read, because I wanted to answer that one.
That one was about the CMS investigational results being prohibited from being shared.
Yeah, so this is one of the sort of deep patterns in information accountability. There was a study, I think Caleb Alexander was one of the authors of it. It's a long time ago. I think it was in JAMA. It was probably 20 years ago. But it sort of gave doctors the choice of being paid for their paid less for failure or having their failure rates be publicly reported. They were much more comfortable with being paid less than with having their failures be publicly reported. This is, I think, a deep-seated piece of medical professionalism. I've written about it. You know, I have enough experience in medical training and at least post-MD training practice that, you know, I can relate to the insecurities associated with making one's experiences very, very public. And what's evolved early on in the Medicare program was that almost any of the interventions that the federal government would take with physicians were then shielded from any other informational accountability. The biggest example of this was until essentially the ACA. If somebody complained about if a Medicare beneficiary complained about their physician, and there was an investigation and there was a finding that the physician had behaved wrongly, the complainant was not informed. That was even held, you know, so the notion of, you know, does the physician, unlike the patient, have a separate interest in confidentiality is, I think, yes. I think this should be passé. I understand the motivations, but yes, I find that ethically troubling. And I think that, you know, we need to be much more explicit about accepting informational accountability in medical practice.
Okay, great. Well, we don't have any more questions at this time. Dr. Stage, I want to thank you for speaking with us today and sharing your thoughts and your wisdom. And thank you to all of our participants for joining us today. This webinar is being recorded and will be available on our YouTube channel in another week or so. So please feel free to share it with your colleagues.
Thank you for inviting me.
All right. Thank you so much, everyone. We will see you soon. Have a wonderful day.
Great presentation, Bill. Thanks so much.
My pleasure, Tom. I hope it was coherent.
It was outstanding. Thank you.
All right.
Let's you and I talk soon. Okay, bye.